TPP, or whether you dislike it, I think we should all agree that this is a terrible way to run a democratic process. Something that has such a major implications for this country should be discussed and debated. Too often, of the TPP dismiss critics as being simply anti-trade. That, of course, is untrue, it's unfair, and it's unproductive. In fact, most of us, or almost all of us, are in favor of actual trade. But that doesn't mean that every single trade deal is a good trade deal, especially one that's negotiated in secret, and especially one that gives such sweeping powers to corporations. A serious debate on such a huge deal is vital to our democracy. This forum, bringing together some of the top experts in their fields, will explore some of the serious problems with the TPP and hopefully convince the government to revise it. If they're not going to revise it, then to at least not sign it or ratify it. We have a packed agenda today, so I'm not going to speak much longer. I'm going to introduce Bruce Campbell. He's a visiting fellow at the University of Ottawa School of Law, a faculty of law. And he's going to welcome you on behalf of the University of Ottawa, and then we'll get right to our panelists. Thank you very much. Bruce.
Thank you, Martin. And I'd like to extend my welcome to you and to the hosts and sponsors. The University of Ottawa, as Martin said, is the host, and specifically the School of Epidemiology, Public Health, and Preventive Medicine, and the School of International Development and Global Studies. And as he said, it's sponsored by the union, the media union, CWC Canada, and the Trade Justice Network. So we have a pretty exciting agenda today. We got 2 blue ribbon panels, and of course the keynote address from Professor Joseph Stiglitz. And they'll give you a rigorous evidence-based analysis of this agreement, what's actually in the deal, and its likely impact. And this, as Martin said, it contrasts with the rhetorical arguments that we've been hearing from the pro-TPP advocates, which, in their narrative goes something like this. TPP is about increasing market access. Increased market access equals more trade. More trade is ipso facto good, and therefore TPP is good, full stop, end of story. There's not a lot more to their analysis. It's the kind of evidence-free policymaking that we thought we'd left behind with the last government. So, as Martin said, the government is now consulting, but there are some signs that it's less than thrilled to hear dissenting voices, and it still hasn't initiated its own impact assessment that it committed to. And I say this not to discourage your participation in the consultations, but on the contrary, I emphatically urge and encourage your participation. And I submit that after today's conference, you will know more about the TPP and that you will want to make your views known to the government. And let me suggest that the Canadian Centre for Policy Alternatives is a go-to place for solid research on the TPP, led by its Trade and Investment Director, Scott Sinclair, who's on the first panel. And there is an impressive series of papers in the works. 3 have already been released and are on the website. 3 more are pending, and at least 3 more are at various stages of completion. And they'll eventually be compiled into a book. But in the meantime, they're available online. So I'll leave it at that, pass it back to Martin, and enjoy the day.
Okay, so we'll get right to our first panel. Our first panel is Gus Van Harten, Megan Sally, and Scott Sinclair. I'll give a little brief bio of them before we introduce each of them before they give their panel, but we'll start with Gus. Gus Van Harten is an associate professor at Osgoode Hall Law School at York University. He taught previously at the London School of Economics. He specializes in administrative law and industrial investment law, and his most recent book is Sold Down the Yangtze, Canada's Lopsided Investment Deal with China. Nice title. Gus will be making a presentation today titled Who has benefited financially from special privileges in the TPP for foreign investors in ISDS? So over to you, Gus, for the first panel. Thank you.
Okay, good morning, everyone, and thank you all for coming. It's wonderful to be able to present to you today, and I'd like to thank the organizers for giving me this opportunity. I'll be talking to you about acronyms, okay? But don't be put off by the acronyms. They're inaccessible for a reason. ISDS stands for Investor-State Dispute Settlement, and we're at the brink of a massive expansion of ISDS in the world because of a few new agreements, including the TPP, the Trans-Pacific Partnership, the Canada-EU CETA, and another agreement called the EU-US TTIP. And today I'll talk a little bit about ISDS is part of trade agreements, even though it has very little to do with trade. ISDS started getting put into trade agreements about 20 years ago, especially in NAFTA. And since then, it hasn't had any further great leaps forward until now we're at the brink of a major leap forward in the role of ISDS in the world. Today, I'm going to make 3 points. The first is ISDS is about giving special status, rights, privileges to foreign investors, foreign owners of assets, and without providing for legal responsibilities to go with that special status. And these are special rights and privileges that go beyond, I stress, what foreign investors would otherwise enjoy in domestic law or elsewhere in international law. That's the first point. The second point is, if we follow the money as to who's benefited from ISDS so far, we will see it has been overwhelmingly very large multinational companies and very wealthy individuals. The third point I'd like to make is the one I've already mentioned. I'll demonstrate it with some graphics. We're at the point of a massive expansion of ISDS, whereby it goes from being a minority, having a minority role in the global economy to being, in effect, an established global institution. Okay, so the first slide, there's nothing there yet, I know. There's a lot of text that's about to come. It'll be like a waterfall. It'll flow over you. I'm not going to dwell on it. My point is, think of the lawyers who are advising big companies and very wealthy people, and think of how they can use these details in their legal strategies to advance the interests of their clients, okay? These are some of the ways in which foreign investors get things through ISDS they wouldn't get otherwise, right? And I'm not going to dwell on these, okay? So they have the ability to challenge a country's legislative, government, and Supreme Court decisions directly at the international level. They have access to very broadly worded standards of foreign investor protections or foreign investor rights or privileges. They have access to uncapped damages awards, that is, public compensation, as the primary remedy for unlawful sovereign conduct, supplemented by non-monetary orders against the state's institutions. There's no doctrine of deference or balancing that we see in domestic law to respect the relative accountability of legislatures or expertise of regulators. There's no requirement to use a country's domestic courts or show why they are inadequate before bringing an international claim. There's no requirement to resort to contractually agreed forums. I know this is legalistic. I'm just thinking, imagine how the lawyers work with this stuff. Okay? The foreign investor has control or influence over half of the makeup of the tribunal that will decide their claim against a country. The arbitrators on the tribunal who will decide the foreign investor's claim against a country, saying, you, the country, have violated my rights. Those arbitrators have a financial interest to encourage more foreign investor claims, among other conflicts of interest. There's no or very limited prospect for review of the arbitrator's decisions in any court, in any country, or internationally. The awards of the arbitrators are widely enforceable against a country's assets abroad. No standing is given in the proceedings to any other affected party except for the foreign investor and the state's national government. And lastly, there's no corresponding right of governments or other affected parties to bring claims against foreign investors in the context of a dispute about foreign investment. Now, I'm not going to explain any of those details. If you like, I can talk to you after. My point is, there are a lot of, from a legal point of view, a lot of benefits that foreign investors receive in ISDS that they otherwise wouldn't get. The very quick slide here, more text. Don't worry, I'm getting to the graphics. I'm just pointing out some of the research we've done, and the one that I'm focusing on today primarily is really the follow the money question. Who has benefited financially so far from the money that the arbitrators have ordered countries to pay, countries and their taxpayers, their populations, to pay to foreign investors who've been successful using ISDS against countries? So first of all, this is something we might call the explosion of foreign investor claims using ISDS. These are claims against countries. This is the year 2000. So in the last 15 to 20 years, this system has grown significantly. Foreign investors didn't use ISDS before then because they either weren't aware of it or they didn't have the agreements in place to allow them to use it against countries. And here's the total compensation ordered by arbitrators over the same period. You can see how more and more money is being ordered for the public to pay to foreign investors because the arbitrators have decided that the country, the public's part of, its legislatures, courts, governments, regulators have done something inappropriate for foreign investors. And that's the year 2005. So it's recent, right? This is a recent development. It's novel, it's new, but it hasn't really gotten fully established yet because not all the agreements are in place yet. Okay? Now we're following the money. All we did here is we looked at what kinds of companies or individuals received the ordered compensation against countries in ISDS. And we found the largest companies were ordered to receive about 73% of the total compensation. These numbers are all approximate, but it's going to give you an idea. Okay? So these are companies with over $10 billion in annual revenue. Very, very big multinationals. Very wealthy individuals were ordered to receive 12% of the compensation ordered. These are people whose net wealth exceeds $100 million. Not quite billionaires, 100 millionaires and up. And then we have large companies taking in most of the rest. These are companies whose annual revenue is between $1 and $10 billion. Other individuals, smaller companies who manage to bring claims as foreign investors really are not taking much of the compensation here. This graphic is making the same point. You see most of the money that the arbitrators have ordered the public in countries to pay to foreign investors is primarily going to the very big companies and to very wealthy individuals. In this graphic, we did something a little bit more. We accounted for the legal fees because ISDS is very lucrative for lawyers and arbitrators. So we subtracted the legal fees from the amount of money that the foreign investors were getting. The average legal fees, we used some data on average fees, about $8 million a case for both sides to litigate an ISDS. That's an OECD estimate. OECD researchers made that estimate. So it's the extra large companies who are the biggest winners. They had an over $6 billion gain from the existence of ISDS, just taking it by itself. But interestingly, the next biggest gain was for what I've called the ISDS legal industry. So these are the lawyers, arbitrators, other professionals who are being paid fees associated with ISDS, and many of whom, I should add, are publicly very positive about ISDS. They do promote it publicly and not publicly, I'm aware. So that's close to $2 billion. That's an underestimate because our data set didn't capture all cases. I would say certainly the ISDS legal industry has earned over $2 billion in total in all cases since ISDS started to explode. And then we have some other actors who are getting modest gains. And here's the big loser is, of course, respondent countries, because they're paying all the compensation, the public is paying, and they're also paying their legal fees and their arbitration fees. Now, this is the next point I want to stress is this is the period in which, this is the 1990 to 1995, this is the period in which the treaties were signed. The treaties that allowed the claims that led to these orders of compensation to foreign investors. Okay, so the treaties under which the claim was brought that led to the money order, these treaties were concluded between 1990 and 1995, almost all of them. The big ones there, one of the really big ones there is NAFTA. NAFTA is still the only agreement like this where ISDS has been allowed on a comprehensive basis between developed economies. Canada has the inauspicious honor of being the only Western developed country to have agreed to ISDS while in the more vulnerable, we call capital importing position with the United States. But the TPP, the TTIP are what would change that and bring in the rest of the developed world into this system. Okay? So, and there's the year 2000. And this is really my last graphic. This is a graphic demonstrating how much a few new agreements can change the whole landscape of ISDS, because that little red arrow, that's where we are now. Okay? Because the black part of this graphic, and I'm using the US economy as a proxy here, okay? So the black part of the graphic represents the amount of the foreign-owned US economy that is currently covered by an agreement that allows for ISDS. And you see it's still a small amount of the foreign-owned US economy that's covered by ISDS. I'm using the US economy because, of course, it's the biggest, gives us the best sense of something approaching the global position. But of course, this is all approximate. I mean, if the TPP were concluded, it would roughly double coverage of ISDS. That's one new agreement compared to probably 50 to 60 existing agreements of the US that allow for ISDS, the most important of which is NAFTA. And this is additional coverage by the EU-US TTIP. One new agreement blows it open. Two new agreements blows it open even more. TPP and TTIP are the great leaps forward for ISDS as a global institution. A couple of more slides, but the last slide I want to get up is if you're interested in more of the data, the methods, the limitations, the studies behind this presentation, I've included the links to that information on this slide. So thank you very much.
Thank you very much, Gus. That was great. And scary. Our next speaker is, by the way, questions. There will be questions after all three speakers have finished. We will have speakers that will come to both mics. This is being live streamed, so when it comes to questions, you will have to go to the mics so that we can get it on air. Our next speaker is Megan Sally. Megan is a digital rights specialist with Open Media, which is an international nonprofit that creates community-driven campaigns to engage, educate, and empower people to safeguard the internet. For the last 2 years, Megan has been studying and campaigning on the TPP and its impact on Canada's digital future. Megan, you're up. That's fine, absolutely.
Great, okay. Thank you. I'm probably one of the only people on the panel who is not an academic, so I will sit at this table. I'll be a little bit more comfortable this way, but I do want to talk to you today about what the TPP means for the internet in Canada. So we're here today to listen to experts, and Professor Joseph Stiglitz, an esteemed American academic, talk to us about trade and making sense of the TPP. And first, I'd like to say thank you to Professor Stiglitz for traveling to be here with us today, and to my fellow panelists as well, and the organizers of this event for inviting me to speak to talk to you about copyright, the TPP, and Canada's digital future. So, as mentioned, I work with Open Media, and for those of you who don't know what that is, as mentioned, we're a community-led organization that works to safeguard the possibilities of the open internet. We believe that the internet should be a place of free dialogue and creative expression. It should be affordable, and it should be surveillance-free. So I wanted to start today by framing my argument with an argument advanced by another well-known American academic, and lawyer and university professor, and that's Lawrence Lessig. You'll note that my presentation is very image-heavy, so you can just take a look up there. There won't be a lot of words that you need to read. So Lawrence Lessig, some of you might recognize, and not just because he ran a campaign for president this year, but because he has been a leader in the conversation about cultural production, innovation, and in Western society for decades. And Lawrence Lessig argues that we're currently in a struggle between a free culture and a permission culture. A free culture being one in which people are free to create, and a permission culture in which innovation can only happen with permission from the creators of the past. The outcomes of this struggle will have far-reaching consequences for art, cultural production, and innovation within Canada and elsewhere. And in his 2004 book, Free Culture, Lessig says that for the first time in our tradition, the ordinary ways in which individuals create and share culture are falling within reach of the regulation of the law. This was in 2004, and I would argue that we've only seen this problem worsen and intensify in the decades since. And I would also argue that it's a big part of what we're seeing with digital policymaking and international trade agreements, like the failed ACTA, like SOPA and PIPA, and what we now see in the TPP. Because after all, what place does digital policymaking and internet governance really have in a massive international trade agreement? I'm not the first person to ask that question. Many wiser and more seasoned academics have asked it before me and are wondering why we're finding policies like this essentially hidden in the TPP. So USTR, the grand architect of the TPP, will argue that digital policies are included in the TPP because there are digital trade barriers that we need to break down between countries. And I'd like to explore that idea a little bit. So any person or organization that is engaged in criticizing trade policy in North America will be familiar with those warm and fuzzy feelings that are associated with the phrase free trade. And I think that we heard that a little bit before. If you criticize trade, you're against free trade, and that's a really difficult position to be in. If you criticize NAFTA, CETA, the TPP, you must be against free trade. I think that as a nation considering joining what would be the largest free trade agreement in the history of the world, we have to take a look at the facts on the ground, the text of the agreement, which we can finally now do, and ask ourselves, is this actually free trade or is it protectionism? We know that the TPP is a Made in America trade deal. This is actually a screenshot from the USTR's website. So here it is, Made in America. And I think, the USTR hasn't been shy about that fact. It's actually right on their webpage. And in particular, more than any other chapter of the agreement, the intellectual property chapter is designed to protect existing big business in the US, in particular in the IP and innovation sector. And I'd like to take a look at some of the policies now in the agreement that will accomplish this. So this is a map of international copyright terms taken off of Wikipedia. So the first thing I'd like to talk about is copyright terms. So under the Trans-Pacific Partnership, Canada will be required to extend its copyright terms from the Berne standard, life of the author or creator plus 50 years, to the life of the author or creator plus 70 years. And Canada, unlike many other nations in the TPP, was unable to negotiate any phase-in period as well for these copyright term extensions. So what that means is that, well, it'll have three effects, actually. The first is that it's going to cost Canadians money. We have no cost benefit, as recently stated, and New Zealand's government did do a cost benefit, and they estimated that the copyright terms alone, the copyright term extensions alone, would cost New Zealanders $55 million a year. And New Zealand is about 1/10 of the size of Canada. So we can imagine that that number would be much greater. I hope that we don't have to imagine it for too much longer and that we'll actually have some numbers to look at. But we can imagine that number would be much greater for Canadians. The second effect is that this is actually going to make it harder for artists and creators to make new works. So anyone who has studied art or innovation will know that all creation is built off the works of previous creators. And as copyright terms continue to get longer and longer, the body of work that artists and innovators have to work with stays the same, and it severely restricts these artists and creators from using the past century of creations in their new works, either because they're not granted permission or because they face a monetary barrier that they cannot afford. And the third effect of this copyright term extension is going to be that it preserves the place of legacy companies in the market and keeps out new entrants. And let me briefly illustrate this point with an example borrowed from Canadian copyright expert, Professor Michael Geist, who I'm sure many of you are familiar with. In the 2015 budget last year, the Conservative government actually extended copyright terms for a specific segment of copyright for sound recordings and performances. Now, Canadian copyright law protects the song itself for the life of the author plus 50 years, and the protections for sound recordings is 50 years. So a decent amount of time that companies get to profit off of the works of others. So Professor Geist points out that earlier in the year, in 2015, a new Canadian company called Stargrove Entertainment started selling cheap copies of some Beatles performances that had passed into the public domain, providing Canadians with a low-priced alternative while still ensuring that the artists and songwriters were compensated for their works. And what happened? Well, Universal Music, eternally unhappy that their monopoly over these particular popular songs had been broken, went on to lobby the Canadian government, which in turn extended copyright terms and effectively killed this new Canadian business model. Now Canadians will pay more for products that they want. Artists are actually getting less revenue because they don't sell as many copies, these more expensive CDs, or whatever they have. And the public domain has actually suffered. So that, to me, sounds a little bit like protectionism. We've killed a new Canadian business model based on the public domain. Another set of provisions under the TPP that I'd like to talk about are digital rights management, or digital locks. Digital locks are various access control technologies, so it can be hardware or software, that are used to restrict the usage of proprietary hardware and copyrighted works. So under the TPP, circumventing digital locks is prohibited, and Article 18.69 of the TPP actually requires Canadians to add criminal liabilities to the list of potential remedies. So it can actually be, you could potentially go to jail for circumventing a digital lock. This, in addition to the fact that Canada is already recognized as having some of the most restrictive digital locks rules in the world, and that looking back on what happened before Canada entered the TPP, it becomes clear that the reason that we actually got those really restrictive digital rights management rules is because they were the price of entry for us actually being allowed to negotiate. At the beginning of the Trans-Pacific Partnership, the United States did not want us to be at the table at all. And we made a lot of changes to our national legislation to allow us to even be allowed to sit at the table. So, the US originally opposed, and now, under the TPP, Canada will be locked into digital locks. So what's the problem with digital locks? Well, here in Canada, we have a flexible system called notice and notice, which is arguably fairer than the notice and takedown system that's in place in our American counterpart system. So we have fair dealing rules that allow copyrighted materials to be used for reasons of education, review, criticism, parody, etc. And one of the ways of stopping even fair uses of copyrighted materials is digital locks. So if you put a digital lock on your products, that way, even if the use is fair, you've already broken a digital lock and you've broken the law if you want to access it. And the question is, how big of a problem is this? Well, DRM is becoming more and more pervasive, and in today's world, you find it on everything from your digital devices to light bulbs to printer ink. Problem number 3, in my count, with the TPP and digital policy, is a lack of flexibility for emerging systems and more balanced rules. I mentioned earlier that Canada's notice and notice system is fairly balanced. And briefly, what this system is it requires rights holders who believe that their copyright has been infringed upon to send a notice through your ISP, so that's Rogers, TELUS, Bell, whoever you pay for your internet service with. So they send a notice through your ISP to the customers asking them to stop and take down the infringing material. This is opposed to notice and takedown, where a notice is sent to the host and the host just removes the content. Now, under the TPP, Canada was able to secure a carve-out for our notice and notice system upon the condition that no other TPP member, current or future, would be able to use this system. Not only does this restrict the ability of countries around the world to follow Canada's example, but most of you know that the internet doesn't just reside here in Canada. And in fact, most of the content that you're accessing all day is not hosted in Canada. And as the much more restrictive notice and takedown system that all other TPP countries will be required to implement continues to spread, we're going to see more and more content disappearing from the web. So finally, I wanted to spend a moment on ISDS. My colleagues have done an excellent job of talking about this, and I'm sure you'll hear more about it throughout the day. But to borrow a quote from an American scholar, media scholar, Robert McChesney, who says, whatever your first issue of concern is, media had better be your second, because without a change in the media, progress in your primary area is far less likely. I think it also holds true that this is true for the TPP. Whatever your first issue of concern is in the TPP, ISDS ought to be your second. The investor state provisions, much to the dismay of internet freedom advocates and others, contrary to what we had originally hoped, do apply to the intellectual property chapter, which means that if we ratify the TPP, Canada will live under constant threat of multi-million or even billion-dollar lawsuits should we choose to change our copyright laws in our own best interest. And with a mandatory copyright review upcoming in 2017, it's hard to imagine that any changes that Canada could make wouldn't run afoul of either existing TPP rules or invoke the wrath of litigious media giants south of the border. So I ask you once again, does that sound like free trade to you or American protectionism? I think that, at least in the intellectual property chapter, the answer for Canadians is abundantly clear. I'd be remiss if I didn't take a moment to talk about the way that this agreement was negotiated. By now, I think we all know that the TPP was drafted in complete secrecy, in particular for the copyright provisions, but also the vast majority of rules discussed under the TPP. It runs completely contrary to our conception of both sovereignty and democracy. We can't have a democracy without an informed citizenry, and this agreement was designed with the purpose of keeping the public away until it was finished. In fact, in a recent talk that Professor Michael Geist gave on the Trans-Pacific Partnership and intellectual property, he recalls when he spoke to a parliamentary committee about the TPP in 2012, and referencing leaked documents to comment on the progression of the agreement, he was met with the statement that the government doesn't comment on leaks in much the same way that they don't negotiate with terrorists. It speaks to the internally insightful words of Noam Chomsky on whether or not democracy and freedom are values to be preserved or threats to be avoided. And in the TPP, democratic participation was treated as poison. Now, I wouldn't be a very good campaigner if I didn't have a plug here, so what are we doing about it? I think that this conversation that we're having here today is a really important step. I think that we do need to get in a room together. We need to talk about what our concerns are, what the impacts are, and what the potential outcomes can be without an economic impact assessment, without an ability to have this conversation openly with Canadians. I don't think that we can move forward in a democratic manner with the TPP, ratifying or not. So we're at the point now where our government here in Canada has asked us for feedback. I won't say it's too little too late, but I will note that after the agreement has been signed is not a great time to solicit input. But Open Media, for our part, is working together with a bunch of other Canadian groups, Council of Canadians, some of us, STAND, formerly Forest Ethics, the CWA, Unifor, other groups who are concerned about the Trans-Pacific Partnership. And what we're doing is we're asking Canadians to submit their feedback to the government. And it will find its way directly to the Standing Committee on International Trade studying the TPP, to our International Trade Minister, Chrystia Freeland, and to local MPs who at some point in the next 2 years will be asked to vote on the ratification of this agreement. So we've got a great tool that we've created at letstalktpp.ca. You can go there, you can use that tool, and when you send your message, it sends to all three of those people. So it will send directly to our trade ministry, it will send directly to your MP, and it will send directly to the Standing Committee on International Trade. We've already had over 6,000 letters sent, and I think that's a really, really big improvement upon the radio silence that we've heard for the last 5 years on the TPP. So let me leave you with this. We can and should be trading with the world, sharing our culture and ideas, but we need to find a way to do it that genuinely engages citizen stakeholders, or the outcomes will be the same every single time. Popular resistance, government negligence, and a deal that serves the entrenched power dynamic and ignores the rest. Thank you.
Thank you very much, Megan. Okay, our third panelist is Scott Sinclair. Scott is a senior research fellow with the Canadian Centre for Policy Alternatives, where he directs the centre's trade and investment research project. He has written widely on the impacts of trade treaties on public interest regulation and is the co-editor of the CCPA series, What's the Big Deal? Understanding the Trans-Pacific Partnership. Prior to joining CCPA, Scott was a senior trade policy advisor with the government of British Columbia. Scott's presentation will be called Democratic Deficit, the TPP's Questionable Legitimacy. Scott.
Thank you, Martin, and thank you to the organizers, my fellow panelists. We're all going to learn a lot about a very important treaty. My focus today is going to be on the democratic legitimacy of the TPP. I intend to examine its democratic credentials in terms of process, substance, and purpose, and of course, mainly from a Canadian point of view. I will argue that the TPP is steeped in layers of illegitimacy. Now, many modern trade agreements are products of a deeply flawed process. They failing to respect basic democratic norms of openness, accountability, and public participation. But the TPP process is all this and much more. Canada and Mexico entered the talks fairly late, in 2012. For 2 years, the Harper government had been lobbying heavily to become part of the TPP, which of course is a hub and spoke agreement, and the gatekeeper was the United States. The Department of Foreign Affairs and International Trade was balking at the demands coming from Washington, but finally the file was taken over by the Prime Minister's Chief of Staff, Nigel Wright, who was sent to Washington to secure Canada's entry, apparently at any cost. Sight unseen, the Government of Canada agreed to accept any negotiating text on which the then 9 current members had already reached consensus. The Canadian government accepted a further condition that it would not reopen any already agreed upon text. And Canada also agreed to not block consensus if it was the lone dissenting voice. By agreeing to these restrictions on Canada's ability to negotiate freely, the Harper government clearly telegraphed its desperation to be part of this agreement, whatever the ultimate cost. Now, as you know, the agreement was finally struck, the deal was finally struck in Atlanta during a Canadian federal election. So parliamentary convention dictates that so-called caretaker governments refrain from taking major policy steps between the time Parliament is dissolved and the newly elected Parliament meets. If they must do so, the government is obliged to fully consult with opposition leaders on any such decisions. And this did not happen. The Conservative government, struggling to stay in power, eagerly dropped the TPP bombshell into the final weeks of the federal campaign. And while this disruptive maneuver did not help them, it did lock Canada into a deal that the US and other TPP parties now insist can't be changed. Now, the entire negotiating process, as Megan has already mentioned, has been characterized by extreme secrecy and undue corporate influence. Most members of the Canadian public or civil society, unions, and non-governmental organizations had few opportunities to be involved in the formative discussions. Meanwhile, as we've heard recently at the pre-hearings at the House of Commons, the Chamber of Commerce was expressing satisfaction with their as many as 10 meetings with TPP negotiators. The Chamber president stated, "We were in touch from time to time with the minister as well, directly and with his office, so that we were kept apprised broadly of the direction in which things were going." Except for a few chapters, the full text was never leaked. And this is really quite unusual for a major trade deal. The ACTA, the MAI, the FTAA, even the NAFTA were all leaked prior to conclusion. WikiLeaks even announced a $100,000 bounty for the negotiating text, and there were no takers. The text itself was highly classified on national security grounds, and anyone who leaked it faced possible criminal charges. In fact, today, all the negotiating documents, except the text itself, remain classified for 4 years after entry into force of the agreement. And these can be quite important documents for understanding the nuances of what was actually agreed to. So the TPP text was not made available to the public until November 2016, after the election. The newly elected Liberal government proceeded to tell Canadians that it would be impossible to change it. Now, during the long election campaign, the Liberals embraced the principle of free trade and the logic behind the TPP. But they decried the secrecy of the Harper government's approach, and sensing growing public unease with the pact, they also promised to hold a full and open public debate if elected. Now, the Parliamentary Trade Committee's pre-study was confined almost exclusively to pro-TPP business groups. Cross-country events have also come up far short of anyone's definition of meaningful participation. For example, in my home province of Prince Edward Island, 2 meetings were held just this week as part of the consultations. Both gave participants little notice, were scheduled during working hours, and were only 1 hour long. The first was by invitation only, with very few groups invited, and the second was open to the public but poorly advertised. Now, some more auspicious signs are that the Trade Committee is planning to travel across the country, and the public has been invited to submit written comments to the Parliamentary Committee, as Megan has already explained. The deadline for that is April 30th. I urge you to grasp these chances to be heard. Whatever the shortcomings of the consultation process so far, these opportunities are simply too important to pass up. I'd like to suggest the TPP is also illegitimate in terms of substance, of outcome. It is a one-sided agreement that is intensely biased towards US and corporate interests at the expense of those of other countries, including Canada, and the majority of citizens throughout the region. It is an agreement of and for the 1%. Now, New Zealand Trade Minister Tim Grosser, I guess you would call him an old hand at trade, he was a driving force behind the TPP, spoke of the ugly compromises needed to complete the agreement, which he compared to eating dead rats. I'd like to suggest that this is not just an unsavory metaphor describing unpleasant but necessary compromises to the higher end of more trade and greater prosperity. Instead, these ugly concessions are actually ends in themselves. The very purpose of a treaty such as the TPP is to coerce governments into making concessions that most would not normally entertain or be able to justify in open democratic debate before their own electorates. I prefer the metaphor of a poison pill to dead rats as a way to describe such trade treaty commitments, which lock in neoliberal reforms and prevent future progressive governments from reversing course or changing direction without risking retaliation. How better to explain entrenching investor-state dispute settlement when Canada is already the most sued developed country in the world? How better to explain extending monopoly protection for drugs when Canadians pay the third highest per capita drug costs in the developed world, and the brand name pharmaceutical companies have consistently broken their promises to invest up to 10% of their sales in research and development in Canada? How better to explain pigeonholing Canada as a seller of raw and semi-processed goods while acceding to US and industry demands on copyright, trade secrets, and digital rights that dig us further into this hole? How better to explain locking in the future privatization of public services right down to the municipal level through so-called standstill and ratchet clauses that prevent remunicipalization of privatized services such as sanitation or transit? No candidate in their right mind would run on such a platform, and fewer would get elected. Yet trade talks such as the TPP provide an ideal arena for negotiators to conspire against their own domestic constituencies, for politicians to tie the hands of future governments, and for corporations to obtain policy changes that would not pass muster in open debate at home. Finally, I wish to suggest that the TPP is also illegitimate in terms of its deeper inherent purpose, its vision for the future. Despite its pretensions to be a progressive 21st century agreement, the vision of society TPP offers is deeply regressive and incompatible with meeting some of the key global challenges facing humanity in the 21st century. And I'm thinking here especially of inequality and climate change. You've already heard from Gus about how ISDS primarily benefits rich individuals and corporations, both in terms of power and the money, at the expense of taxpayers and the public interest. Megan has argued convincingly that the IP provisions overwhelmingly benefit already wealthy rights holders at the expense of consumers and innovators. You will hear several times here today from Dr. Stiglitz and from Geronimo Capaldo about the impacts of the TPP and similar deals in increasing already rampant global inequality. As Naomi Klein argues persuasively in her latest book, addressing the existential threat posed by rapid climate change will require more and more assertive government intervention and regulation. And unfortunately, the TPP strips governments of the tools they need to address this runaway climate change. Extreme investor rights agreements like the TPP are a relic of an era when market fundamentalism, the belief in the virtues of fully liberalized markets, was the prevailing political wisdom. It's time to move on. There is very significant opposition to the TPP in the United States from across the political spectrum. I take this as a sign that the ideology driving the TPP is exhausting its reserves of legitimacy in our southern neighbor. Canadians, and especially our political leaders, would be wise to heed this. At the very least, we should not take a single step further towards ratification until the fate of the TPP in the United States is clear. Despite the shaky start, the new Canadian government must take the time needed for a truly full and open public consultation where everyone can be heard. And I urge you all to participate in that. Thank you.
Thank you very much, Scott. Those were three excellent panel discussions, it's hard to believe, if there was a government official here, and they were invited, both at the senior level and junior levels, that they wouldn't be convinced. But that's our challenge here, is to make sure that we have an informed debate. We're now going to open up the floor to questions. So any questions you jotted down or want to have, this is the time. As I said, we're live streaming this, so you want to go to either this mic on this side or this mic here. And while you're getting up there, I'm actually going to put the first question to the panel, and it's something that Megan touched on briefly, but maybe each of you could go into it a bit further. What can Canadians do to get our government to get this information into their heads and to be brave enough to make the decisions that have to be made on the TPP?
I'll start because this is kind of our area of expertise. I mean, what we've been trying to do, and Open Media has been working on the TPP for the last 3 years, myself for 2 years, is to first work towards educating Canadians about what's actually happening. As mentioned before, as recently as late last summer, 75% of Canadians had never heard of the agreement, which is egregious. So certainly spending some time, like I said, doing what we're doing today, making sure it gets out to as many people as possible, and having the conversation about what's actually in the TPP is an important first step, because you'll never get the critical mass of people that you need to argue against it if they have no idea what they're arguing for. And then the next step is to engage with the processes that have been, the channels that have been offered to us. We are really excited to see that there's an opportunity for genuine citizen stakeholder engagement now, and also to make our own roads. Sometimes you're not offered a pathway, and you have to forge it for yourself. And I think that Canadians are finding a way to do that through events like this, through other outreach projects, through connecting with groups. We work particularly on the intellectual property and copyright implications of the Trans-Pacific Partnership, but we see how it has implications for health and labor and the environment, and connecting with those groups and forming a solid wall of opposition is really, I think, what we need to be able to do.
Gus or Scott, any?
I would say from my personal experience, I've been following ISDS for about 20 years. It was not on the public agenda until a few years ago because organizations and members of the public put it on the agenda. Experts who kind of are critical in the inside, we don't have much impact because we're outweighed by a very organized lobby, pro-ISDS lobby. It's lawyers, arbitrators who work in the field. It's corporate lobbyists. It's really the only way to influence that, I think, that I've seen is by these concentrated efforts. And we can all do it in our lives. Talk to people about it. Everyone you know, and when you get a chance, don't burn yourself out. But certainly make submissions to the politicians and all of that. But if you know someone who works in the media, explain to them about it. And one other thing, be patient with people. ISDS is shocking. It's hard to believe how far it goes. But I'm sorry to say it's true. But so there's a certain level of patience required to explain it when people just think you're just making it all up.
Scott?
Well, Martin, I'll just take the opportunity. Bruce has already plugged our series called What's the Big Deal on policyalternatives.ca. We have 4 studies published. We'll have 10. They're going to examine almost every aspect of the deal from every angle by respected experts, including people like Gus, who's looked at the investment chapter, and scholars here at the University of Ottawa, including Ron Labonte and others you will hear from later. So I really encourage you to go there and other places to inform yourself about this agreement and its many, many facets, which are very marginally related to international trade as we would normally conceive it, and as everyone else has said on this panel, to take advantage of the opportunities that have been afforded to us and to make your voices heard in the consultation process.
Thank you. Yeah, the problem, of course, is when you try to speak to people and you mention the word trade, their eyes immediately gloss over. And then the second thing is when it's something as complicated as this agreement, it becomes that much harder to get their attention. But what we're trying to tell people is this is not just a trade deal. This is a huge corporate rights deal that has a tremendous implication on our society and our democracy. That's the way I think to get at people. We're going to start at this side. We'll alternate mics. Go ahead.
Good morning. My name is Andrei Litvinenko. I'm a JD MA student here at the University of Ottawa and the Norman Paterson School of International Affairs. I very much appreciate the substantive critiques of how this agreement was negotiated in regards to a democratic deficit and some of the subject matter that's in it with regards to digital rights and intellectual property. My question is in regards to investor-state dispute settlement. And to play the devil's advocate, because there's certainly no shortage of cases where an investor, Canadian or otherwise, was very poorly treated in the country where they put their investment. Somewhat recent case I can think of, and it might be a little radical, is the Desert Line case, and I believe it was in Yemen or somewhere in the region. Long story short, the state did not respect their domestic court's decision. They did not pay the payment. They started bullying and intimidating the investors, so much so that they were detained. They had their other fundamental rights taken away. It was a very difficult situation, and it was through ISDS that they were able to get some form of justice, fair compensation, and to some extent an introduction of moral damages into that field where the state just goes so far beyond the pale of what it should be allowed to do. I'd like to bring it closer to home and ask about what your thoughts are on the Keystone XL case are and how the Americans handled that in the context of their own election and leading up to President Obama's last election, where, from the facts I'm aware of, that project continuously passed all environmental assessments. It was given the permits. Our Canadian company invested money. They had the resources on the ground, and then it was just canceled, and the American political system said this is not going to pass by. In the American system, they can choose to do the trial by jury. And when Canadian investors have been in that kind of situation, they found it very difficult to win in a domestic American court where the opposition is appealing to the jury's sentiment of we need to protect American interests, these are foreigners, that kind of thing. So now we have an opportunity to go through ISDS and defend the Keystone project, whether you agree with its environmental merits or not. It is a situation, at least on its face, that it seems that we weren't treated fairly. We were treated arbitrarily simply because of their politics. So where is the fairness for a Canadian interest? And what value can ISDS have in legitimate cases like that where it doesn't seem that a foreign investment has been given a fair shake? Thank you.
Everyone's looking at you, Gus.
So Desert Line Products versus Yemen, I use that example too as a case where I do think the foreign investor was mistreated. I haven't taken time to give examples of the cases where the use of this system has been abused by foreign investors and by, frankly, the arbitrators who've interpreted these treaties in sometimes astoundingly expansive ways. The Desert Line Products case, I mean, the point is you can give examples of cases on both sides. And my answer usually is foreign investors themselves will benefit from a system that's procedurally fair, judicially independent, open, in the manner of a reliable judicial system, which we're very well familiar with in the domestic context and in the international context, because most foreign investors, especially small players, will never be able to afford to bring a claim. So they benefit from the effect that a trusted, reliable, fair system has. And ISDS falls short of all of the adjectives that I've mentioned. I didn't spend time going through it. It's clearly not judicially independent, procedurally fair, or open in the manner of courts. But there's another element to it. If we want to have a system that resolves disputes in a way that's fair substantively, that means foreign investors can't just have very elaborate, extensive rights and privileges in this system. They should have responsibilities too. And those responsibilities should be actionable and enforceable in the same process as their rights and privileges. This system is crazily lopsided in favor of foreign investors when you compare it to any other legal system that's designed to resolve disputes between asset owners or property rights holders and the state, which often involves third parties. So to give you an example of a case from Canada that comes to mind is a case called St. Mary's versus Canada, involved a quarry in Ontario. That dispute about that quarry had been dealt with in domestic proceedings in Canadian courts, in Canadian tribunals. There's no way you can say that those processes were unfair or abusive to the investor. In fact, they're far superior to ISDS itself. And in those processes, one of the reasons they're superior is because all kinds of other groups affected by that dispute, local landowners affected by the quarry, local medical officers of health, municipal governments, they all got their basic right to have standing in the proceedings to the extent of their legal interests. In ISDS, they were all denied that right, and it is fundamentally procedurally unfair. Okay? That's one example of how this system fails in its claim to provide fair, independent resolution of disputes, and that fails foreign investors who care about those principles, and most of them do, just the same as I do. It fails them too, let alone everyone else. Okay? So that's my main response to, well, what about the foreign investors who get abused? Is shouldn't foreign investors also care about having a fair and independent system that's balanced? The second point is, you mentioned politics. Politics gets mentioned a lot. Of simply say, one person's politics is another person's democracy. Okay? And sometimes governments, legislatures change their decisions in democracies. And foreign investors need to be aware when they invest in countries, and they are aware, that you take political risks. The democracy can work in one direction, it can work in another. Other things we call politics can do that. And foreign investors account for that when they decide which countries to invest in. That's actually part of the marketplace. ISDS, a simple way of putting it, I would say, is a little misleading, but it gets the point across. It's like the nanny state for foreign investors. Okay? Because it's a state intervention in the marketplace to distort the marketplace. Domestic investors don't have access to ISDS. Foreign investors who don't have the money don't have access to ISDS. They don't get all these special privileges and rights, including the ability to avoid their own contractually agreed dispute settlement forums, which is quite remarkable that ISDS arbitrators actually allowed that. Okay? All of those benefits distort the marketplace. Okay? They favor the big players, the well-established players at the expense of everyone else. As you can tell, I could go on about this for a long time, and I very much appreciate the question. It would be nice to have further discussion of it in a seminar on the topic.
Okay, thank you very much. Yeah.
I'd like to just make a few quick points on that. The first is that actually Canadian investors' rate of success using these mechanisms has been very low. And we have a study on our website that examines that. In many cases, that's a good thing because a lot of the claims are outrageous. Now, I also want to point out there are alternative means to protect investors. There's private risk insurance. There is publicly funded risk insurance. And there's not even a requirement to exhaust local remedies in the domestic courts. We can't automatically assume that they're not protected. But there are other means. Now, against that, we have to set off Canada's record as a defendant in investor-state dispute settlement, which has been very poor. We have lost, settled 8 cases. We have paid out damages of $190 million. Gus mentioned the St. Mary's case. Look at the Bilcon case last year, where an environmental assessment process, or the results of an environmental assessment process were basically overturned by a NAFTA Chapter 11 panel. and in which the dissenting arbitrator called, you know, a severe case of regulatory chill. Now, I'm not going to duck the Keystone question. I think the Keystone case is a perfect example of an abuse of this system. You would have to be living in a cave. Investors have to assess regulatory risk. They have known for a long time the possibility that they would not receive regulatory approval. They have not been denied access to the American courts. They are in the American courts now. They have the same rights as any other investor in that highly advanced court system. If they have a case that President Obama was outside, not intra-virus in exercising that decision, then they can make that case in the American courts, and that's the place to do it. So I think it's a terrible abuse of this system, which is so prone to these types of abuses.
Okay, thank you, Scott. We'll go over to this mic.
I'm Janet Parry, interested on behalf of the Health Coalition, Ottawa Health Coalition. When have we seen such secrecy in anything? In all my life, I haven't seen it hidden so well. At this stage, it seems to me that that's our best weapon. We can beat on that because my first real inkling of it was when I got on frantic messages from Vancouver saying that the whole pack of human beings had made lives too hot for themselves over there, and they were all coming over. I don't know whether it was true, but it was overnight. They were being transferred to a hotel here. Get out there and meet them, you know. So we did, but we were a pitiful little crew. And I personally was thrown out. I was on my walker, and I had a woman with me in a wheelchair, and we were thrown out of the hotel by massive goons, one male, one female, and to whom I said, I don't want to come with you. I want to know where the Canadians are, because this was in that wonderful pavilion place at the top, and they were all having their breakfast. Of course, we should have been there before their breakfast, but, you know. Anyway, there were the Canadians in a little tiny group there, and I had a lovely notice which said preposterous, because a young friend of mine said she knew what all those P's stood for. They stood for preposterous. And so we've chipped away at it ever since. Odd thing, you know, the content of the milk and the beef, and, you know, we did have some successes after a lot of hard work through the years, and they, of course, will go. And we talked to Dr. Porridge about the fact that we'll never get our health accord, let alone our pharmaceutical arrangements. However, she did start quickly to talk to the bulk buyers, so that was the best she could do at that stage, I suppose. Anyway, well, the question, have we ever seen such secrecy? So I think that we ought to cash in on that. You know, why are they so secret? We know why now, but we didn't till just now.
Okay, we'll ask Gus, from a legal perspective, have you ever seen such secrecy in agreements? Or?
Well, don't get me started again. You know, there is much greater openness in other international negotiations. You can understand there's some reasons for confidentiality in international negotiation, but the TPP has been, you know, when you connect it with the timing in Canada, to have this deal locked up right before the election, I don't know how you repair that. In terms of legitimacy, the only way I mean, this sounds far-fetched, but the only way I can see to repair that from a democratic legitimacy point of view is to have a national referendum on the TPP and give people a chance to vote after a public debate. But that's just a wild-eyed academic thought.
I can speak briefly to some of the things that we've experienced. I can't say, have we ever seen such secrecy, because I haven't seen a lot of other agreements personally. But you know, Obama has called this the most progressive trade agreement in the history of the world. It's also the most secretive. And you know, Open Media has been trying to go to as many negotiating rounds as we possibly can. I know that in 2012, our executive director went to a negotiating round in New Zealand, and they had a stakeholder meeting, which was basically a kettled area of just people with signs. Like, that was their stakeholder meeting. That was what counted as stakeholder engagement. There has been, changing of venues at the very last moment before negotiating rounds. They won't announce the hotel that it's happening in until the moment it's happening, so that nobody can come and ask them questions. There's been ducking of meetings. And even within Canada, you expect in a trade agreement industry is going to be consulted, but even within Canada, folks like Jim Balsillie, co-founder of RIM, has said even industry was not consulted. So this is an incredibly secretive trade agreement. And the argument stands, of course, some things need to be secretive. Sure, there's part of trade that I'm sure would be better, certain conversations would be better had behind closed doors, but all conversation behind closed doors, absolutely unacceptable.
Well, I can just say I don't remember, and I've worked on a lot of trade negotiations, I don't remember any major negotiation as secretive as the TPP, in terms of access to negotiators, in terms of access to text, in terms of the kind of leaks of negotiating documents that people like me typically gain access to. It was a desert, and it is the first time I remember, with the exception of the investment and the IP chapter, that when the text was actually released, I actually didn't know what was in it. I was just like everyone else, trying to catch up and read it. By which time, of course, it was too late to change it.
I was glad to hear today that the Chamber of Commerce got 10 meetings with the minister. I had been trying for months to get a meeting with the top trade negotiator, and it was arranged and everything was fine, and then just shortly before, all of a sudden it was mysteriously canceled because she was too busy. There you go. Lots of time to meet with the Chamber, though. Over here.
John Cadam, I'm coming back to ISDS, and notwithstanding all of the odious characteristics that everybody in the panel have emphasized, I was struck in the metrics that you put up about the claim amounts, that I think in 2013 the total claims was something in the order of $5 billion, which and that there's